Hello, my name is Jonathan Plender, and welcome to my presentation surrounding the Coastal GasLink pipeline and its effects on the Wet'suwet'en people of British Columbia. Some of you may have heard of the $6.2 billion project spanning 670 kilometers in the province, a plan proposed in 2012 receiving the Crucial Environmental Assessment Certificate in 2014, allowing for its inception. Since, the Wet'suwet'en people have been protesting at their various camps in an attempt to impede construction. This presentation will explore the various legal and historical issues associated with this case and seeks to provide some insight into the reasons it's happening as well as potential solutions to said issues. I will begin with a brief overview of the topic and tensions within this case, complemented by contributing factors that aggravate the issue for the Wet'suwet'en people. Next, I will elaborate on the historical context, focusing on the lasting effects of colonialism and giving case-related historical analysis of the treaty rights involved herein. Following this will be a slide focused on parsing out the specific legal issues that are actively being fought in court and some that have a broader relationship with the tension between Indigenous people and the state. Next, I will provide some updates regarding recent developments in the case, and finally, I will conclude with some closing thoughts and potential solutions moving forward. Now, on the surface, the problem in this case lies within the tension between TC Energy, the private company running the Coastal GasLink project, the province of British Columbia, the elected band chiefs, and the tribal chiefs of the Wet'suwet'en tribe. To give some background on the case, the Coastal GasLink project aims to build a 670-kilometer pipeline stretching from the Dawson Creek area to a facility near Kitimat, where the LNG Canada will prepare for its export to global markets by converting the gas into a liquefied state. Now, TC Energy, the company in charge of the project, publicizes its victory of having signed support agreements with all 20 elected First Nation councils along the path, including some Wet'suwet'en bands, but the nation's 5 hereditary chiefs say it's illegitimate without their consent as well, which they have not given. Some contributing factors are colonial attitudes from the government when there are monetary gains at stake, the discord between elected band council and hereditary chiefs, as well as paternal decisions being made by the courts, which we will get into a little later. Now we're moving on to some historical context. Violence against and disregard for Indigenous consent has been a staple of settler-state Indigenous relations since the colonial period beginning in the 17th century. Colonialism is defined as control by one power over a dependent area or people. A critical juncture in the establishment of a European vision for Canada was the Indian Act of 1867. It introduced the concept of Indian status, the band council system, the Indian reserve system, and gave way to the Indian residential school system. Although the Coastal GasLink pipeline project is a relatively new development, the broader Indigenous community has been victimized for centuries, largely due to the Indian Act. Along the way, some progress has been made in terms of reversing the colonial effects on Indigenous people after the horrors they've endured over the past centuries. An example is the 1973 Calder decision, in which, for the first time, post-colonial Canadian law acknowledged that Aboriginal title to land existed prior to colonization of the continent. In 1995, the Inherent Right policy was created to guide self-government negotiations with Indigenous communities, a formal mechanism that paved the way for further Indigenous freedoms. The final historical example involving treaty rights is the 2000 Niska Final Agreement, where a successful land claim was made over territory in British Columbia. It was the very first formal modern-day comprehensive treaty in the province. Moving on to the legal issues at hand, in this case, we go back to some of the inherent tensions that I mentioned earlier. The first of which is the discord between the elected band council and the hereditary chiefs. There's currently a disagreement within the Wet'suwet'en First Nation where elected council supports the pipeline project and hereditary chiefs oppose it. To give you some insight as to key reason why they disagree, hereditary chiefs are a form of Indigenous governance that pre-exists British colonization and are very real governments with distinct traditions, rules, regulations, and protocols for how communities ought to be governed. Band councils, in contrast, are a structure that was introduced by the federal government of Canada through the Indian Act. Working under different mandates, they sometimes have competing interests, and thus, consultation practices exclusively being with the elected councils are problematic. Another legal issue at hand is the benefits agreement that was signed by the council. It was found to have been overly limiting on the Wet'suwet'en civil rights. It stipulated that they may not protest for the duration of construction of the pipeline no matter their issue with it. This clearly violates the constitutional protections of freedom to express, associate, and peacefully assemble. Finally, in December of 2018, the BC Supreme Court ordered an injunction against the Wet'suwet'en people who were protesting to be enforced by the RCMP. Now, this just goes to illustrate the consequences when First Nation groups do not conform to their band council agreements. Since the original injunction, protests have persisted, leading to the arrests of 14 anti-pipeline demonstrators at a Wet'suwet'en checkpoint, and because of this, in January of 2019, the same Supreme Court of British Columbia extended the injunction to cover the entire Forest Service Road, including a second checkpoint. Since the second injunction was ordered, members of the Wet'suwet'en First Nation reached a deal with the RCMP to let construction crews reach sites of the pipeline. The hereditary chiefs have assured TC Energy that vehicles blocking the river would be removed. Justin Trudeau came out with a statement regarding the issue as well, after he was faced with heated questions about the pipeline debate. He said the development concerning this case showed the need for a different relationship with First Nations. He said, and I quote, "The way we are doing resource development, construction, exporting of our resources is changing in this country." As of now, the Office of the Wet'suwet'en Affairs plans on appealing both injunctions together, as well as attempting to revisit the benefits agreement that has drawn so much criticism from both community members and outside legal experts alike. With this being said, TC Energy plans on moving forward full steam with their Coastal GasLink pipeline project and will use the courts in BC to help them along the way. They continue to legitimize their efforts by citing the band council signatures and insist that they are doing everything they can to maintain an informative and beneficial partnership with the First Nations communities that they cross paths with. Moving forward, some food for thought concerning solutions to the previously mentioned issues begins with a conversation around affording legal status and voting rights to hereditary chiefs, especially on issues that concern them directly as well as their constituents. Furthermore, the contractual legitimacy of a benefits agreement that so severely limits civil rights should be questioned and revisited. And finally, Wet'suwet'en land has never been ceded to the government in the first place, meaning no land has ever been surrendered to Canada by treaty, and technically, the hereditary chiefs are the title holders of those unceded lands. But since no court decision has been made about this dispute, the courts continue favoring the government in their decisions. This needs to change, and a judicial decision about the title of this land needs to be made quickly. All in all, this is one of many stories outlining the paternalistic attitude of the federal and provincial governments in Canada towards Indigenous peoples and illustrates the need for continued advocacy and change in legislative approach. Thank you guys very much for listening to my presentation. I hope you guys have learned something insightful and that it inspires you to advocate for Indigenous rights moving forward.